Good evening, everyone.
Good evening, sir.
Good evening, sir.
Good evening,
I
sir.
hope both classes are represented. The civil litigation class. Is there anyone from the civil litigation class here? Well, we informed the civil litigation class, and it's because of the civil litigation class that we are starting by 5:30. Surprised that none of them. Is there anyone from MID, civil litigation, in class presently? Hello? No one.
Most likely,
Please
sir.
let me give a call. Because they are aware. They are aware. Well, maybe they will have to join us. This link that we are using, I believe that we have used it before, isn't it?
Yes, sir.
Okay, so it's not as if we change Zoom, we change link. So if they have not joined, it's not going to be because we change the link. Oh, okay. They don't have the link. Seems as if they don't have the link.
Good evening, sir.
Yes. Mind, have you joined?
Yes, sir.
Okay.
But I'm seeing some other people on the link who are not offering civil litigation.
Well, they are LLM
Who
cyber.
are not in our class, rather. Let me put it that
Yes,
way.
they are LLM cyberspace people. I told you the first day that I'm merging two classes.
Oh, okay, sir.
They've been
Okay.
here, because their own class was supposed to be as from 5. So they've been waiting for you. I
Okay,
deliberately delayed them till 5:30.
okay,
I
sir.
didn't
We
know
are
that you
joining
don't have
already.
the link.
We
Okay,
have our people,
please,
yes.
let's be using this link subsequently.
Okay, sir. Okay, sir.
Mm.
Thank you, sir.
So I welcome everyone. Can somebody remind me where we stopped last week? I think we were trying to look at the technique of the subject. Is that not so? Hello?
Yes, Prof. Good evening, Prof.
Good evening. I think we are trying to look at how the court will arrive at applicable law. We didn't hold lecture last week, but
Yes,
the
Prof.
previous time, that was what we were trying to do. And I said
Yes,
the
Prof.
first thing is to identify the class of dispute. That's what we call characterization or classification. And I said the importance of classification is to be able to arrive at what is called connecting factor. The connecting factor varies from subject matter to subject matter. Then we were looking at different types of subject matter. We look at contracts. We said that if the dispute has something to do with contract, the court will apply the law that the parties intended to govern. And that intention may either be expressed or implied. And in the absence of implied and expressed declaration of intention, the court will apply the law with the most significant connection with the facts. Then we moved from contract, we went to tort. We said that the court will apply what is called lex loci delicti commissi, the law of the place of the tort. Okay, even though common law courts would apply what is called double liability rule, but the most common connecting factor for tort is the law of the place of the torts. Then, if the dispute relates to marriage, if the dispute relates to marriage, there are two categories for purpose of connecting factor. The first one is formality, and the second one is capacity. What do we mean by formality? What do we mean by formality as it relates to marriage? Formality are all of those formalities required to solemnize a marriage. For example, a monogamous marriage would have to be done either in a religious place, church or mosque that is licensed for that purpose, or at the registry. There would have to be publication of bans. There will be witnesses, there will be certificates. Some countries will have prescriptions to the dates when that can be done, etc., etc. So all these are questions of formalities. And now, if after the marriage, one of the parties seeks to nullify the marriage on the basis that form was not complied with, the party seeking to nullify the marriage may not necessarily be taking the proceeding in the place where the marriage was done. And so the court would have to apply a connecting factor. The connecting factor is called lex loci celebrationis. Lex loci celebrationis, the law of the place of celebration. That is the law of the place where the marriage was formally solemnized between the man and the wife. So that is for formality. But there is what we call capacity, or which marriage lawyers call essential validity. Under this category, you have issues like marriage age. You have issues like prohibited limit of affinity and prohibited limit of consanguinity. You have issues like continuous validity of previous marriage, because a person who is married to somebody before cannot be party to a new marriage with another person. So issues like this are issues of capacity. When they become the issue upon which one party is seeking to nullify the marriage, and the connecting factor is no longer lex loci celebrationis, it is now going to be lex domicilii, the law of the place of domicile. So let me give you an example. Suppose two Nigerian domiciliaries married in Accra, Ghana. By the fact that the marriage took place in Accra, they would have to comply with the formal requirement of Ghanaian law. They cannot say that they will be doing the marriage under the Nigerian Marriage Act, because the Nigerian Marriage Act is governing formality of marriage in Nigeria. Since they are celebrating the marriage or solemnizing it in Ghana, it is the Ghanaian marriage law, whatever name it is called, that they would have to meet. So suppose tomorrow one of them seeks to nullify the marriage on a ground that is falling under form. Even if the case is going on in Nigeria, the connecting factor that the Nigerian conflict of laws prescribe will be lex loci celebrationis. That is the law of the place of celebration, which is Ghanaian law. Okay? But if they are seeking to nullify the marriage on any of the grounds that fall under capacity, for example, one party is saying that he or the other party, she or the other party were not of marriage age, then that's a question of capacity. And our connecting factor will be law of the place of domicile. Since both parties are domicile in Nigeria, it is Nigeria's law prescription that the court will apply to determine that question. So that is the distinction between lex loci celebrationis and lex domicilii. Lex domicilii, the law of the place of domicile, would govern essential validity or what is called capacity issues, whilst lex loci celebrationis will govern issues that come under formality. Okay? Then we have issues like succession, wills, and what have you. Issues like succession, wills, and what have you. What is the connecting factor? The relevant connecting factor for those ones is also domicile. For example, if you want to succeed to the estate of a deceased person who is an international person by having assets across the globe, okay, you will not have to be looking at the laws of all the places where he has assets. You will look at the law of his last place of domicile before death. So if he was domiciled in state Y, inheriting him will be based on the law of state Y, notwithstanding that the assets are scattered across the globe. However, the rule is that if the assets movable. Sorry, I think the thing went off.
Yes, sir.
So removal simply means that when you are applying the law of a particular country, you are applying the whole of it, including its connecting factor, including, its conflict of law rules. So suppose the property is located in state Y, but state Y's connecting factor is lex domicili. Okay, law of the place of domicile. Okay. So what it will mean is that the lex situs will defer to the lex domicili. So you will end up applying the lex domicili. Okay. Let me go over it again. If the asset is not immovable, if the asset is movable, it's very simple. You just look at where was the deceased domicile, where was it last domicile, and you apply the law of that place to determine who inherits him, irrespective of where the movables are across the globe. But where the asset is or include the movables, the basic connecting factor is lex situs, law of the place where the land or immovable property is located. The reason is that since you cannot move the land, you cannot subject it to the law of another place as regards ownership or whatever. However, if you now examine the conflict rules of the locus of the property, and the conflict rules there also applies lex domicili, you will apply that lex domicili because of the concept of ruva. Okay? So suppose a man dies with immovable property in state Y, and the issue of who is entitled to inherit him is being determined in Nigeria. Okay? Nigeria will apply lex situs. That is the law of the place where the immovable is located. But if upon examining the conflict of laws of the place where the immovable is located, it is discovered that that place will also apply lex domicili. Nigeria would then go ahead and apply lex domicili. So what has happened there now is that instead of applying the internal law of the place where the property is located, Nigeria will apply the complete law, including conflict of law, of the place where the property is located, and do exactly as the court of that place would do. So that's what we call a RUVA. Well, try to understand it is a technical concept. If you don't understand it, it doesn't matter. We just have a general idea of what we are talking about, how you arrive at the law that will govern a dispute. So
I didn't get the name of the concept, sir.
we call it RUVA. We pronounce it RUVA, but we spell it RUENVOI. RUVA. It simply permits the court to apply the conflict rules of the otherwise applicable law instead of its internal law. You know, in the example we gave, if it is only the internal law, there will be no recourse to lex domicili. But because we are taking the entire law of that country, including its conflict rules, we will now see that its conflict rules are accept application of lex domicili, and we will end up applying the same lex domicili we would have applied were it to be that the property was movable. You know, I told you that if the property of the deceased were largely movables, you will apply the law of the last place of domicile of the deceased. Okay?
Yes.
But if they include the movable, with regard to the movable part of it, the applicable law governing inheritance will be lexitus. That is law of the place where the movable is located. But if the place where the movable is located also applies lex domicili as its own connecting factor, then RUVA will require you to apply that lex domicili and not the internal law of the place where the property is located. That process is what is called RUVA. Okay? We don't go into too much detail of it. We normally do that with the LLB and LL.M people. But we just want you to have an idea of this technical area. Okay? So that is that with the technique of the subject. There are some other technical aspects of it, but you should basically be able to tell us how will the court determine applicable law to a dispute under private international law or what is called conflict of laws. The answer simply is that the court will first determine under what subject head the dispute falls, looking at the facts. And those of us who are lawyers know that a dispute might come under contract, might come under special contract like sale of goods, hire purchase, insurance, company law, etc., etc. Then it might come under what is called delict, civil wrong. Okay? It might come under property, might come under succession, etc., etc. Each of these subjects will have their own connecting factor. Every state would have its own connecting factor for each of the subjects. And the connecting factor we are basically looking at are the connecting factor of Nigeria. Okay? So have a broad understanding of those different connecting factors, and you at least have an idea good enough for you to know the technique of the subject. So the next point we'll be looking at is if your connecting factor has directed you to the law of a particular country, okay, that law becomes the applicable law. The other word for applicable law or applicable foreign law is known as lex corsia. Lex corsia. C-A-U-S-E-A. Lex corsia. Okay? So the next question we're asking is there any reason, is there any ground upon which a court, having identified the lex corsia, we refuse to apply it? Are there grounds for excluding otherwise applicable foreign law? You have identified the subject area that the dispute falls into, and you have identified the connecting factor. And applying the connecting factor, you have arrived at the law of state X as the law that will govern the dispute. Of course, the law of state X is not your own country's law. It's not the law of the country whose court is entertaining the matter. Is there any reason that the court can give to say, yes, this case is supposed to be governed by the law of state X, but we will not apply it? That is what we call grounds for exclusion of otherwise applicable foreign law. Grounds for exclusion of otherwise applicable foreign law. There are some grounds upon which a court, a forum court, may nevertheless refuse to apply the otherwise applicable foreign law. The first ground is if the otherwise applicable foreign law is not pleaded or proven. If the otherwise applicable foreign law is not pleaded or proven. What do we mean by this? You know that in the courts, what you prove are facts. The judge is appointed because he's a repository of knowledge of the law. What the lawyers will simply be doing is addressing him, directing his attention to the relevant law, but they won't be proving the law. Okay? So what they will be establishing before him are the facts, and they will plead the facts and tender evidence to prove it. Okay? Now, if a case has foreign elements and by the technique, the law of another country applies, do you expect the judge to be a repository of the law of another country? The answer is no. So if one of the parties will benefit from the application of foreign law, then that party is the one that will have to plead that foreign law and establish it by evidence. For example, if it is the statute of country X that will govern the matter as the law of country X, you will not just be citing the statute. You will bring the statute and tender it as evidence before the court. you bring the statute and tender it as evidence. Then, if it's an area of law that needs expertise, you will call experts who have knowledge of that law in that country as your witness. So that's what we mean by pleading and proving foreign law. So what happens if you are not able to plead and prove foreign law? Does it mean that the case will be thrown away? The answer is no. The correct position in conflict of laws is that if the otherwise applicable foreign law is not pleaded or proven, then the court will apply forum law. The court will do what? The court will apply forum law. And the presumption is that, well, laws of different countries are identical. If the otherwise applicable law is not the same with our forum law, then one of the parties would have pleaded it, at least the party who will benefit from that difference would have pleaded it. Okay, let me give you an example. In some American states, they have rules, they have laws prohibiting recovery from a car owner by a passenger who was a gratuitous, who was giving a lift. In some other countries, they don't have such rules. In some other states, they don't have such rules. So if an action is instituted in the state of California, for example, and California does not have such a rule, but the defendant is saying that the accident occurred in another state, say New York, okay? And that in New York, the owner of the car who drove it would not have been liable because under their own law, you are not liable to compensate a gratuitous passenger. It is who will have to plead that New York statute. He would have to tender it before the court in California. In order to prevent him from needing to tender it, they have a full faith and credit clause, which is more or less like a waiver of proof. But if he now fails to mention it to the Californian judge who is entertaining the matter, the Californian judge does not say, well, we don't know what the law in New York says. Therefore, we cannot pronounce any judgment on this matter. What the Californian judge will simply do is to say, well, neither of the two parties have told us what the law in New York is. We will therefore proceed on the assumption that New York law is not different from Californian law. And so, on that basis, they will apply Californian law. Okay? So that's what we mean by failure to plead or to prove. If your connecting factor directs you to a foreign law, but you fail to establish that foreign law, then forum law will govern the dispute. Okay? That's one. Two, the second ground on which basis and otherwise applicable foreign law may be ignored is where the foreign law pertains to crime. Where the foreign law pertains to crime. Criminal legislations are described as local legislations. A criminal proceeding is a local proceeding, never an international proceeding, in the sense that it is exclusively governed by the law of the place where the proceeding is going on. So, because crimes are local offenses, you cannot be bringing somebody to court in Nigeria to face prosecution for a crime he allegedly committed abroad. Okay? There are a number of authorities on this one, but we don't want to bore you with too much detail. What you should just know is that once it is an offense, and the offense is alleged to have been committed abroad, then the person should have been prosecuted abroad and not here. Okay? However, sometimes the statute of the forum might provide for what is known as double criminality, in which event the wrong conduct of the defendant abroad is what is criminalized as a fresh crime here. The problem with this is that most of the time, there will be constitutional provisions on double jeopardy, which will permit the person to plead what is called atrofos acquit or atrofos convict. Okay? So, you see some of the cases related to this area, there are cases where the cases in this subject area are cases where people's assets are forfeited. If, for example, somebody went through an investigation in his country, and his country, by way of punishment, decided to forfeit his assets across the globe, that order of forfeiture will have effect in the country where the investigation was done. But for so much of the assets that are outside that country, the order of forfeiture will be a nullity. Okay? The order of forfeiture will be a nullity. You'll be given the case of a king of Spain who was investigated in Spain, and the Spanish government decided to forfeit his assets wherever located. And the king had money in bank in England. And so somebody now wanted to enforce that forfeiture order of the Spanish government in England. The court, of course, held that it is not applicable because it is in Spain that is a criminal or is a convict. He's not a convict in England, and the penalty imposed by the mere fact that it is a penalty, it is punishment for an alleged crime, cannot apply in England. So if you want to seize his asset in Westminster Bank, you must find another reason, not the fact that he was already convicted in Spain. So that is the second ground. The third ground, based upon which you will not apply foreign law, is if foreign law relates to tax, foreign revenue law, you don't apply foreign revenue law. So suppose the government of a foreign state, through a nominee, has filed an action against maybe a citizen or somebody else in Nigeria, okay, to recover tax from the asset of the person in Nigeria. The case, that provision of their law that they want our court to apply as the governing law will never be applied, because the courts will not act as a tax gatherer for another government. So that's number 3. Number 4 is what we call public policy, forum public policy. Forum public policy. You know that countries of the world have different attitudes to questions of morality and what have you. And so some of the times, the right of remedy that you may have under foreign law might be lost in the forum court, because the forum public policy finds the foreign law very insulting, very nauseating. Okay? I will give you an example. There are some countries of the world that permit same-sex relationship and confer rights on parties to such relationship. And so if you have a same-sex relationship constituted under the law of, say, Italy or Brazil, okay, and the parties are presently in Nigeria, and one of the parties want to enforce his rights under that relationship, the question is, which court will he go to in Nigeria to assert that he has a right? The right is properly constituted under Italian law. Italian law governs it, and he wants the Nigerian court to apply Italian law as the otherwise applicable law. The Nigerian court will tell him that, yes, Italian law governs this your relationship, but Nigeria will never acknowledge rights arising from same-sex relationship. So that's what we call forum public policy. He could go elsewhere. He could leave Brazil and go to Italy, or leave Italy and go to Brazil, and that right will be enforced, because their own policy, their own public policy does not find the law nauseating or dishonorable, so, or insulting. But in the Nigerian court, such an order will never be given. So you sometimes will have a situation where public policy of the forum will not permit the foreign law to be applied. So those are the 4 grounds upon which otherwise applicable foreign law will be ignored. Okay? So on that note, I will stop anything on the choice of law, and I will move to the main issue, which is choice of jurisdiction. Where do you go when a matter has a connection with more than one country? Okay? What rules do you examine and what have you? To be honest with you, I want to start that one next week. Each and every one of you should try and buy my book on the jurisdiction of Nigerian courts in causes with foreign element, so that we can move fast in that area. So, but I want to take any questions on what we have done so far, beginning from introduction of the subject to the 3 questions that the subject will answer, and to the technique of the subject, and to the grounds of excluding otherwise applicable foreign law. I want to entertain questions on those within the remaining period we have today. So as from next week, we will now start with the major issue, which is the question of where do you litigate, and what are the rules governing that? Okay? So, any questions? Hello? I'm waiting. Oh.
Yes, sir.
Hello?
Yes? Hello?
Hello, sir.
Hello?
Yes, sir.
Yes? Yes.
Sir, I not really a question, but I didn't quite understand the explanation you gave about where the grounds of exclusion as for crime. I was not very clear with it. If you can just please recap that particular point, I would appreciate.
Okay. Now, I said that crimes are local offenses. You cannot be said to have committed a crime unless it's against a particular law. For a wrong to be a crime, there must be a written law that prescribes it as such, and the written law must have gone ahead to prescribe punishment. So that written law must be law of a particular country. It is possible that there are similar offenses, but you only commit offense against a particular statute. Okay? So when a conduct amounts to crime, it is only the country where it was done that can prosecute you for it. Except there is what you call mutual assistance, by which countries assist one another through arrest and repatriation of offenders. The criminal procedure of every country, including powers of arrest, detention, and what have you, are local, in the sense that you only exercise it in respect of a crime that was committed in your land. That is why countries will enter into extradition treaty, that this offense will not be punishable except under my law, but the person is in your country. Please transfer him here and all of that. So the issue is that some of the time, A sues B, which would ordinarily look like a civil case. But the basis upon which A wants to recover from B or wants some order to be given against B is penal law, is criminal law of another country. So once that becomes the case, the court should hand up the matter and say, well, we can now not be applying foreign criminal law. Okay? So, and I gave an example, there's an example I normally give in the book of Morris, example of a former king of Spain, okay, who was investigated for offenses of corruption. And at the end of the day, a decree, a Spanish decree, forfeited all his assets wherever located. So this king had monies in one of the banks in England. And so the bank was now sued by the nominee of the Spanish government to recover the fund. What is the excuse? There are so many excuses of which you might want to take money from somebody's account. Maybe he's indebted to you. Maybe he has reached a contract. Maybe he has promised to pay and he has not paid. Maybe he stood as a surety for a third party and uses that account as security. All of these are valid grounds upon which an English court will be ready to entertain your claim. But in this particular case, the Spanish authority is asserting that by its decree, this man had lost his asset in England. And so the English court said, no, we cannot be applying Spanish criminal law here. Okay? The basis of seeking to enforce otherwise applicable Spanish law in this instance is criminal, is penal, and we will not apply foreign penal law. So that's what we mean. That's what we mean when we say that. That's what we mean when we say that if the foreign law is penal, it is not going to be applied. So connecting factor would have led us to that foreign law, but we will not be able to apply it because it is not within the power of the court to apply the criminal law of a foreign country in the forum. Is it clear?
Yes, sir. Clear. Thank you.
Any other question?
Yes, sir. From my own aspects on the issues of succession and wills, I
Yes.
think it doesn't really balance well because okay, so you mentioned that for movable assets, so that the law that you apply is the law of the place, the last place of his domicile.
Yes.
Then for immovable assets, the law that will apply is the lex situs.
That is the law of the place where the immovable is located.
Is
Yes.
located, yes.
Yes.
Unless you are the lex law of the lex situs is allows for the lex domicili to apply for immovable assets. I don't know if I'm correct.
Yes. Yes. So in which case you will do what is called rouvoi. You will
Okay.
do rouvoi. Let me explain it again. I know that's a very technical point, and because we are just flinging the topic, we will not be able to spend 1 or 2 lectures as we normally do for the LLB student on that point. What we are saying is this. You know, every country will have our internal law. Then they will have their own conflict rules. Okay? The conflict rules of a country are the ones that direct the country as regard applicable law to a dispute. So somebody dies, leaving immovables in, say, Ghana. Okay? Our conflict rules, our connecting factor is lex situs, as far as succession to his immovable is concerned, the law of the place where the immovable is located. So that means that has directed us to Ghanaian law. But Ghanaian law can mean at least two things in the context. Ghanaian law can mean the Ghanaian internal law. That is the Ghanaian law that a Ghanaian court will apply in purely Ghanaian circumstances. But it can also mean the whole of Ghanaian law, including Ghanaian conflict rules. So Ghana, being a common law country like Nigeria, would apply lex domicili, whether the property is movable or not movable. Okay? Even though it will also apply connecting factor of lex situs. So here in Nigeria, the court is bound to determine who will inherit the person's land in Kumasi. The first thing the court will do is to say this is a subject area of succession, but the property is immovable. The connecting factor for succession to immovable is lex situs. So I will go to Ghana and apply the law of Ghana. But when I want to apply the law of Ghana, I will apply the whole of the law of Ghana, including its conflict rules. And I will then find that just like Nigeria, Ghana will apply lex domicili. So if the man died domicile in the Gambia, I will through that route, through the route of Ghanaian own connecting factor, apply the Gambian law. So when I do that, it will be said that I have applied RUVA. The alternative is to say, no. Lex situs, Ghanaian law. What is the Ghanaian law that a Ghanaian court will apply in purely Ghanaian circumstances? When I say that, when I use that test, what will be said that I have done as a court is to reject RUVA. I have rejected RUVA, I've applied internal law. They call it the internal law theory. Okay? So what I'm trying to say is that our own connecting factor is lex situs. Okay? But we will apply RUVA if the country where the immovable is situated will not apply his own law in the circumstances, would rather apply his own connecting factor, which is most often lex domicili. So in that way, the supposed difference between movables and immovables is removed. For movables, you go straight away to apply the lex domicili, the law of the last place of domicile of the disease. For immovables, you apply the lex situs. But most of the time, especially if the property is located in a common law country, you end up applying the same lex domicili because the connecting factor of that country will be lex domicili. And your own RUVA consent will permit you to do as the court of that country would have done. Okay, is it clear?
Yes, sir.
Any other
Very
question?
good.
Any other question?
Okay, sir.
Good evening, sir.
Hello?
Yes, sir. Good evening, sir.
Yeah, good
During the
evening.
last class, you mentioned that you were going to touch on the principles that apply to adoption and I've forgotten the other, but you have not.
All of those subject areas, legitimacy, adoption, and whatever, all of them are governed by domicile. We call them
Okay,
law
sir.
of personal status. They are governed by domicile. The same domicile that govern capacity to marry, succession, wills, all of them. All of those subject areas are governed by the lex domicili. So the propositors' place of domicile law would govern. Whether it's legitimacy, legitimation, adoption, succession, okay? We are just
Yes,
touching
sir.
all of those topics so that you have an idea of how we arrive at applicable law. We are not treating them in any detail. The real issue is dispute resolution. Which court do you go to? Which country do you go to litigate? And what are the rules that govern such issue? Okay?
Okay, sir. Thank you, sir.
Any other question?
Yes, good evening, Prof.
Yeah, good evening.
Yes, just as a follow-up to the question you just answered, you also pointed out that we'll be looking at trust. So what's the applicable law or the connecting factor in trust?
Okay, trust.
Yes.
Well, trust is almost the same thing as contracts. Okay? If a
Yes, sir.
person is formally creating a trust, and the trust assets include assets scattered across the world, or the trust beneficiaries are not located in one state, it is most likely he would express his wish or intention as to a governing law. So like contract, in contract we say if the parties express their intention as to governing law, so be it. So if a testator or a donor who is creating a trust express his intention as to governing law, so be it. So express, just the same express implied the law with the most significant connection as applies to contract also applies to trust. So the creator of the trust might have expressly stated. Failing that, you might be able to construe from the terms of the trust and everything relating to it that this is what he wanted to govern. That's implied. Failing that, you look at the different contacts. You look at the location of the assets. You look at the seat of the executors or trustees. You look at all of those factors and you say, well, everything about this trust is circulating around statewide. So statewide will be the territory whose law will be most significantly connected with the trust, and it will then apply. So that is how we arrive at applicable law for trusts of international dimension. Okay, but the easiest way to do it is somebody has assets scattered across the globe or has children or beneficiaries across the globe and you want to benefit them, he should himself express that this thing is going to be governed by the law of so country. Okay?
Yes, Prof.
Hello?
Thank you, sir.
Yeah.
So,
Yeah,
Prof, is also the same thing with competition, antitrust. Oh, hold on a moment.
well, antitrust state legislations that are expected, that are intended to ensure that there is fair competition. Is that not so? Hello?
Yes, sir. Yes, Prof. Yes, Prof.
The antitrust provision of a country's law will govern if that country is the choosing law. If it is the expressly choosing law or impliedly choosing law or the law with the most significant connection, then its antitrust provision will govern. Do you understand?
Yes, sir. Thank you, Prof. Thank you, sir.
Any other question?
Good evening, Prof. Good evening,
Yeah,
sir.
good evening.
Please, can we have the course hotline for this course, sir?
I didn't give you a course outline. Did I not? I'm sure our first class was physical. Was it not your
Yes,
class
sir.
where I dictated what we are going to do?
For March,
You have not given us.
No, this is LL.M Cyber.
Okay,
LL.M
it
Cyber,
is the
sir?
right people that I gave it to.
mine does not
Yes, sir.
end.
Okay, okay, don't worry. I will, immediately after the class, I will just draft an outline, which is, I remember telling you people
Yes,
that it's going
yes,
to be
Prof.
an amalgam of the two classes, but there will be one or two lectures that after we are finished, I might just want to do with the this resolution class, because they want us to emphasize cyberspace for them. They want us to emphasize internet transactions with them. And internet transactions, by their very nature, are the type of transactions that in modern day will always require a knowledge of conflict of laws. Because you are doing transactions online, you do not think of a breach. When the breach occurs, then you begin to look at, I was in Nigeria transacting with somebody in America. Which court do I go to? Okay? So you need to understand this subject area very well. You need to understand the international law dimension of conflict. You need to understand interstate, okay? And possibly interlocal, okay? So what I will do is, instead of me dictating it to you people now, I will set it out and send to your respective WhatsApp group. I think you both, Ojo is the class captain for Might,
Yes, sir.
and Temitope is the class captain for cyberspace. So I will just send the outline. The Might people, you have a prospectus and it is stated there, but I know that it is it's a bit on the brief side, the way it is stated. So I will make it a little more detailed so that you know what next we are to do, and so on and so forth. Okay?
Thank you, Prof.
So no other question?
Yes, sir. One more thing, sir. Just wanted to know for information purpose. We typically LLM students do seminar papers, so I don't know if we'll be doing one for this course and if we should prepare for that.
No. I will give you people assignments. I will give you people assignment that will cover your CA. Do you understand?
Yes, I understood.
Thank you, Prof.
Yes. So I see you next week.
Sir, sorry, sir. In
Mhm.
respect of our standing results, diplomatic and consular law, we haven't seen it, sir.
Yes. As I'm talking to you, I have the scripts right here on my table, and I'm marking them. You know, in fact, I thought I had marked it, but I now remember that because of strike, we had 2 years. We had 2 years together. So it was that of the previous year that I had marked, not your own. Don't worry, maybe before next week, you will see the result.
Okay, thank you very much, sir.
Yeah. So on that note, let me check out.
Thank you, sir. Good night.
Thank you very much, sir.
Yeah, good night.
Thank you, sir. Good night, sir.